Good morning, everyone. Welcome back to the Prajnya Gender Talk Series, July 2022 edition. We are extremely happy to have Professor Ruchira Goswami with us today. I will read out her bio and then I will tell you about her. They don't necessarily amount to the same thing. Ruchira Goswami teaches at the National University of Juridical Sciences, Kolkata, where she offers courses in sociology, human rights, gender, and law. She was the head of the Center for Child Rights, NUJS, a multidisciplinary center set up in partnership with UNICEF with the mandate of research, documentation, and advocacy on child rights issues. A British Chevening scholar in human rights from the London School of Economics, her areas of interest include feminist movements and legal reforms, children's rights, representation of law in films, and intellectual property and human rights. Her publications are in international human rights law and women's rights, and intellectual property and women's rights. She has taught in several institutions, including Presidency University, Jadavpur University, IISWBM Kolkata, and in International Development Studies, University of Oslo, Norway. She has recently worked on 2 research reports as project director on implementation of the Protection of Children from Sexual Offences Act in West Bengal, sponsored by the UNICEF Office of West Bengal in 2016, and is co-investigator in an Indian Council of Social Science Research sponsored research project, Reconceptualizing Domestic Violence, Shifting Discourses Within the Women's Movement, 2016 to 18. She is closely associated with several human rights and women's rights organizations and conducts workshops and capacity building programs on human rights issues with various stakeholders. And this is the other part. How do we know her? We know her because last year, Prajnya was part of the pilot phase of a larger project called Surviving Violence, which was about how domestic violence survivors access help. And Prajnya piloted the Dharmapuri phase of that research. And as we were completing this, a team of researchers, including Professor Goswami, joined us on the project, which has now moved out of Prajnya. And we have all been working together on the same project on a national scale. So this is how we know her. And we know her as one of those rare people who can be extremely serious and focused and erudite while actually also having a great sense of humor and a sense of joie de vivre, a sense of joy about everything. So we are so happy to see you here. And, now we won't let you go anywhere. Now, this is actually your second appearance. You were on the campaign program. So, bus, now finished. You're permanently anchored in the Prajna community. So welcome, Ruchira. Over to you. Can't wait to listen.
Thank you so very much. And it's absolutely a pleasure to be a part of the Prajna community. Thank you, Swarna, all Prajna members. Sudhar, great to see you for this opportunity to talk a little bit about an issue that I've been teaching and working on for some time. And so I will go straight into it at the moment. So the topic for today's discussion is child marriage, mapping the legal conundrum, is what I titled. We could call it child marriage or early marriage. I'm using the term child marriage because that's how the law uses it. So what I propose to do briefly is to talk about the journey of the law. So I'm not getting into statistics or any kind of data around whether child marriage is increasing, decreasing, which is something that needs a lot of attention, of course. I'm also not talking about several kinds of national and regional interventions around child marriage, which again could be an interesting policy discussion, but would try to focus on the law that try in India that prohibits child marriage. But that is not all that I will discuss. I will also try and discuss the complexity between the law that prohibits child marriage in India and other existing laws that also have to do something around the issue of underage sexual relationship. Okay, so that's what I will do. So I will try and break this up, starting very briefly.
Ruchira,
Yes.
just to let you know, I think we will all turn off our video because your voice is breaking up, at least for me.
Oh, I see. Okay, sure. Just let me know if it is okay. So, I will start very briefly with the history of this legislation. So, child marriage, as perhaps we all know, um, and the law around it is a colonial one. So, the first legal interventions around the customary practice of getting children married happened in the British era. And then there were several amendments and other changes in the law. And then we have the current law as it is. So, very quickly, we know that child and early marriage is a customary practice amongst nearly all communities in India. And the law which tries and intervenes and tries to prohibit child marriage, the legislations originally were around Hindu laws, right? Around the Hindu community. But today it is a statutory law, which means that it is for all communities. So where do we find this history? Somewhere in the year 1880 is the starting point. So I will talk very briefly about two cases. One in around the year 1884, where we see a young woman of around 22 years of age called Rukma Bai from Maharashtra. She was married as a child when she was around 10 years of age to a person, but she never went to her in-laws, and the marriage was never consummated in the sense that she has never had any relationships with the husband. Now, there is a long history about why Rukmabai becomes Rukmabai, but I'm skipping it at the moment. So, when she was married, it was not that her parents wanted her to be married, but there was a lot of force from the community, and so she was married to this guy who, according to Rukmabai, was not a very capable person and definitely not an ideal husband. She remained in her native family and wanted to carry on with her studies, which she did. But then we see that when she's about 20, which is like old at that point of time, her husband kept on asking her to come to the matrimonial home, which she refused. And then what he did was that he filed for a restitution of conjugal rights. Now, what is restitution of conjugal rights? It's a legislation that came in the British period and it is still there in the Indian legal system, which means that if a husband or a wife is not doing the duties expected of him or her, then the other party can file for a restitution, which is that he or she makes a claim on the husband and the wife. This happens mostly in cases where the husband has gone elsewhere, he's kind of left the wife. It being a gender neutral law, it could also be applicable for to women that they can file for a restitution of conjugal rights against the husband. But if we know the Indian case law, we know that it is mostly men who claim for this RCR, especially when their wives refuse to come and stay with them. They have gone off to their natal family when she's gone out for work, etc., etc. So Rukmabai's husband made this claim in the court for RCR, saying that she should come and stay with me, and consummate the marriage. She refused, saying that this person is not ideal. I don't want to stay with this person. Interestingly, Rukmabai, in around that 1880 period, she was trained in English, she was educated, and she wrote under a pseudonym in the then Times of India. And the pseudonym was A Hindu Lady. That is the pen name that she used. And she talked about the plight of women at that point of time. Plight of Indian girls, Hindu girls getting married at a really young age, around the age of 8 or 9. And she was continuously writing in the paper around the plight of this early marriage and the plight of the Hindu widow after that. And the Times of India, her writings actually went abroad. So, she was kind of a known name. When Rukmabai refuses to go back to her husband and the RCR is filed, interestingly, there was this fight between the Hindu orthodoxy, who said that why, she will not go. I mean, this is unheard of. And on the other hand, you have the social reformers of India who was supporting Rukmabai's claim. Now, what claim did she make? She said, I refuse to go back to my husband for 2 reasons. Reason 1 is that I was married at the age of around 10, or maybe around 10, and I had no idea of what was happening to me. And 2 is that nobody asked for my consent whether I wanted to be married. And even if I would have consented, does that consent really matter, given that my age was only around 10? This, for us who work around legislation through a feminist lens, was a very, very important statement for a woman to make in 1880s, when we talk about prohibition of sati, prohibition of child marriage, and several other legislation around women's rights in the colonial period. We usually talk of social reformers and their contribution. We don't usually talk of how women make claims on the legal system and on the social system. And for the first time, we hear something called consent to marriage coming from a woman. In fact, coming from a man, perhaps also. Now, this was a very, very strong argument, and that found resonance also in the United Kingdom, in Britain, where the first wave feminist movement had gained ground. So a lot of suffragists were supporting Rukmabai. The Privy Council means the erstwhile highest court in colonial India, something akin to the Supreme Court now. The Privy Council was in a bind. On one hand, the British Parliament, in the UK, there was this discussion of supporting Rukmabai. You had social reformers in India supporting her, talking about child marriage, and the Hindu orthodoxy, which was up in arms, saying that you cannot trouble customary practices like this. The Privy Council ruled against Rukmabai and said that if, they passed an order saying that if she does not go to her husband's house and respond to the claim of restitution of conjugal rights, then she will be imprisoned and the law will take its own course. Interestingly, Rukmabai says that I would rather be imprisoned than going to that man. I refused. Now, there was a problem. Her husband recognized, and so did the Hindu orthodoxy perhaps, that now Rukmabai will become a martyr to the cause, that a woman would rather be in jail but she would not live with a man that she did not choose to get married to. The case was settled outside court. So it is not a landmark judgment kind of case at all. So it was settled outside court. The man said that if you give me a certain amount of money, I will leave you. And she gives that money. And the husband leaves. Rukmabai then goes on to rebuild, sort of get control over her life, goes abroad and becomes a doctor. So that why did I talk about Rukmabai's case is because of this assertion that is made by a woman on the right of her to consent to marriage, and therefore what is that women have a consent to sexual relations, and opening up the debate on age of sexual consent. So that there's huge historical analysis of age of consent debates in law. And I think Rupabai is a huge watershed here. The next case is from Bengal. Rupabai was from Maharashtra. Both Bengal and Maharashtra, as we know, have been spaces in which the social reform movement was pretty strong. The other case is an 1891 case where a young, again, an 11-year-old child, Kulmoni, is married off to a 29-year-old man. The marriage is consummated. The husband has forced sexual intercourse with this young, with this child, and Kulmoni dies of bleeding on the first night of her wedding. Kulmoni's mother then again appeals to the court, saying, "Is this what marriage means? I wanted a life for my daughter. I did not want her to die. So should we really do something about it?" Between Rukmabai, and this is 1891, between Rukmabai, which is 1884, the court, the out of court settlement was done in 1888, I think, and Kulmoni is 1891. In this period, this discussion and Rukmabai's claim that the age of marriage should go up from 10 to 12 at that point of time. Kulmoni's case that this, when girls are raped because of marriage, and all of this leads to the age of consent debate, and therefore the first legal intervention on the customary practice of marriage happens, where the age of marriage goes up. And there have been amendments in the law after that, from 10 to 12 to 14. And finally, in 1929, we have somebody called Harbilas Sarda, who moved a private member's bill in the parliament. And again, and for the first time, we have a statutory law, a specific legislation on child marriage, right? So prevention of child marriage. It was called Child Marriage Restraint Act. And I'm emphasizing on the term restraint because it recognizes that it can't be stopped completely, but it will be restrained. So 1929, the first legislation around child marriage happens in pre-independent India. Since then, there have been several amendments. And finally, the law as we know today, where the age of marriage for a girl is 18 and for a boy is 21, that comes through an amendment in 1978. So we have this Child Marriage Restraint Act, which came in 1978, and that continued till 2006. In 2006, this law is replaced by another legislation. So it is not amended, it is completely replaced by a legislation called Prohibition of Child Marriage Act. I want to draw your attention to the difference in the terms from restraint to prohibition, which shows the intention of the state that we want to prohibit child marriage. But as we all know, the child marriage is continuously gone on. Early marriage, so maybe not at 8, but at 15. And from the National Family Health Survey records, etc., we still know that the age of marriage and the age of having the first child is roughly around 16 between 15 and 16 in India. So you have a law which says, at least in 1978, that the age of marriage for girls is 18. But in reality, it's the case. So there are these policy level interventions and all that. This does why early and child marriage remains a problem is this very strong patriarchal control. And we know that there is this case, which perhaps many of us know, which is known as the Bhavri Devi case, where a social worker, Bhavri, she tried to stop child marriage in certain districts of Rajasthan, and encouraged to teach her a lesson that, how dare you sort of try and stop these customary practices. Um, while for Bhavi was a kind of a rape to teach her a lesson, we know that Bhavi's case actually led to a whole new legislative framework, which is on sexual harassment at workplace. We find Vishakha guidelines coming in. Why? Because Bhavi was a social worker in Rajasthan, and she was working for the government of Rajasthan. And it is during that work, because of her work, that she was raped. And therefore, it is just not a case of a criminal legislation, but what about the responsibility of the employer in protecting the rights of the woman employee? And that is what the NGO Vishakha pushed for. And we have the Vishakha guidelines, which in 2012 became the sexual harassment sexual harassment at workplace prevention law. So Bhavi's case was also there in the 1990s. In the early 2000s, we have another case also emerging from Rajasthan, where a woman called Shakuntala Verma, she was also working for to prevent child marriages, and her hands were cut off because she was trying to resist a long-established customary practice. So we see that the tentacles are really, really strong of holding on to child marriage. Let us now move to a couple of other things. In 2006, why did we have a new law instead of amendment to the 1929 legislation, 1978 then, instead of the Child Marriage Restraint Act? Why did we have a new law called Prohibition of Child Marriage? And the reason for this is that a completely new clause comes into the law. Apart from punishments being strengthened in the new law, punishment of the family, more people were punished in the new law, in the sense that not only the father who gets the daughter married off early, but also the priest, also the matchmaker. Anybody who's come to attend that wedding, knowing that this is a young girl under the age of 18 who's been married off, everyone can be implicated by the law. The punishments are stronger. All of that is there. So on one hand, the law is made stricter because we are moving from restraint to prohibition. That was one thing. The second thing is that a completely new clause comes in. And we say this, void and voidable marriages. Now, what does it mean? Void marriages means that they are, we use a term in law called void ab initio, in the sense that this is just prohibited by law. What kind of marriage? If a girl has been forcefully married off, if she's been trafficked, and it's a false marriage, and then after that she's been trafficked, where the intention is criminal in the first place, those she's been abducted and married off, right? So there is a criminal activity leading to the marriage of the girl. It could also be the marriage of a boy, by the way. Child marriages are gender neutral legislation. But in most cases, we know in India, it happens to the girl, so I'm using the word girl. So any child who's being married off using a criminal activity, that is a void marriage. Void as in that is illegal, prohibited by law. But then we see, and this is how customary practices hold on, we see that there is something called voidable. Now, what is voidable? In the sense that the child was married off by the family, right? Now the marriage has happened. Maybe in 2 years' time, she's also had a baby. Now, what if you declare that marriage illegal? Then what happens to that girl uh, in the circumstances in India where we know that families, once they have married off their daughter, there seems very little scope for them to come back to their natal families. We know this happening to adult women all the time. A reason why women stay in violent marriages is that the natal family doors are forever closed to her. She's a young girl who was married off. Probably she does not have the resources to build her life independently. So recognizing this, the law uh, sort of gives a leeway that if a marriage has happened, then let it be. And you give an opportunity for this child, could be a girl or could be a boy, to declare that marriage voidable when they come of age. So, a girl, say, who's married at 16, for example, when she turns 18, and within 2 years of that, majority plus 2 years, so by the time she's 20, she can appeal to the court that I want this marriage to become voidable. I want this marriage to go. Voidable is distinct from divorce. So there is no divorce. That marriage is declared as null and void, as if it didn't happen. But you give this choice to the person who was married before the marriageable age, right? So both the boy and the girl can do it. So the boy on turning 21 can say that I was married at 19, I want to declare this void. Possible. For a girl, when she turns 18, and within 2 years of that, she can say that I was married off really early, I don't want this marriage, please declare it null. So the law gives a provision for this. It's debatable, right? So on one hand, saying marriages are prohibited. On the other hand, there is this window through which, there is this back door through which such marriages can stay, and they are kind of legalized. And again, the reality check of voidability is also important. That will a woman actually say that I want to declare this marriage void? What is the percentage of girls in India who would be able to do this? On what strength will she declare her marriage as void? Uh, Especially in circumstances where she is not very highly educated, is not economically independent, maybe she's had a child, she has nowhere to go. What are the women without the support state, without the support of, say, NGOs who can declare their marriage void? So there is an entire reality check on the voidability clause of the Prohibition of Child Marriage Act, saying that really does this work? Is something. There are studies that have been conducted where we have seen that going to the courts to declare voidability has become nearly impossible. You go to a court, you have to go 100 times. As we know, there are these delays that happen in court, and girls find it nearly impossible to sort of do this, carry on with their voidability. So this is the conundrum of the implementation of the Prohibition of Child Marriage. So this is one part of the discussion. What is the other complexity here? And here I'm going to sort of bring in a couple of other laws to complicate the picture a little bit. Let us now move away from this statutory criminal law legislation on child marriage and move to another provision of criminal law, which is the Indian Penal Code, section 375, which is the rape law. So what does section 375 say? That what constitutes rape? What are the constituent factors by which one is a case of rape? Against her will, against her consent, if the consent has been obtained under duress, etc., etc., when she's been intoxicated. So there are these 6 clauses, and that constitutes rape under section 375 of the Indian Penal Code. Now, that had an exception clause. That had, it does not have this now. There was an exception clause. What was that exception clause? One exception clause was when husband has sex with the wife not being under 15 years of age, that is not rape. Okay. What does this mean? It means that a man can have sex with his wife, forced, whatever, and that is not rape. So there's this entire debate around marital rape. Okay. So that husbands cannot, quote unquote, rape their wives. So that is fine. But that is not what we are discussing. Look at what this says. It says under 15 years of age. So what does this require? What is the age of the wife? As long as the wife is 15 plus and a man has sex with the wife forced, that is not rape. Now, what is the first complexity? The complexity here is that on one hand, you have the Prohibition of Child Marriage Act, which says that the minimum age of marriage of girls is 18. But at the same point of time, another criminal clause, which is the Indian Penal Code, says that the wife can be 15 years of age. Okay? So there is problem 1 here. So these two are at loggerheads. Problem number 2. The age of sexual consent under the rape law is 16 years. What does this say? When a man has a sexual intercourse with a woman who is less than 16 years, that is statutory rape. Okay. So within the same legislation, you have 2 ages. First age, the age of having the age of sexual consent under the Indian Penal Code is 16 years. So what does this mean? That if a girl who is 16 years even consents to sexual intercourse, who's say 15 and a half years, less than 16 years, consents to sexual intercourse, that is irrelevant. Her consent is irrelevant. So that is statutory. Under 16, you cannot have sex with a minor for a girl. But in the same clause, the exception says it's 15. So for any other woman, the age of sexual consent is 16. For a wife, it becomes 15. So within the same section 375 of the Indian Penal Code, these two problems were there. And the Prohibition of Child Marriage Act says it's 18. Age of marriage is 18. So now we have complicated the scene all the more. Interestingly, there is another law here. This law comes in 2012, and which is the Protection of Children from Sexual Offences Act. We never had a law that prohibits sexual abuse of children. And so you have this specific legislation coming in 2012. And what does this say? This says that the age of sexual consent is 18. Why does this say that the age of sexual consent is 18? Because the age of marriage for girls is 18. And age of so if any person is having a sexual relationship with a person who is under age, that again is statutory sexual offense against a child. Because the age of adulthood is 18. So POCSO now says 18. Age of marriage, PCMA says 18. And Section 375 of the Indian Penal Code has 16 as the age of consent and has 15 as the age of the wife. We've complicated further. Now, you also have something called family laws in India, which governs laws of marriage, divorce, custody, adoption, maintenance, succession, and all that. Interestingly, there's this debate, and it went on, and there are case laws that have gone both ways, is that Islamic marriages, there the age is you can marry off a girl on attainment of puberty. Puberty can be even lower, but roughly it's understood it's around 15. So an Islamic marriage where the girl is around 15 years of age, therefore, could be legal in the eyes of law. And that is why the IPC had this exception clause that the wife needs to be 15-year-old because Islamic marriages are allowed at the age of 15. So, can you use marries their minor daughter through Muslim marriage? And there are case laws which go both ways, saying that family law allows, Islamic laws allow for marriage of a girl of age. And you have the Prohibition of Child Marriage Act, which says 18, and the POCSO also says that you cannot have sexual relationships with them under the age of 18. So it's a complete conundrum. Which one do you give more credence to? Should POCSO and Prohibition of Child Marriage, because they are these statutory legislation, they are these specific legislation, trump family law? That's another legal conundrum. What do we do about it? So finally, there was a little bit of a resolution that happened around Section 375 of the Indian Penal Code. And this came in 2017. Independent Thought is an organization which filed for a writ petition, which is they filed for a case in court, saying that how can you have this, your POCSO and your PCMA is 18, and you say that the age of sexual consent in case of an unmarried girl is 16, and for a married girl, it's 15. These are completely contradicting each other. You cannot have these contradictory laws. That was the appeal that they made through the writ petition. And the Supreme Court gave a verdict in 2017, which removed the exception clause of 15 years under child marriage, 15 years under Section 375, and said that no, the age of marriage being 18, so you remove that exception clause that if a man has sex with his wife under 15 years of age, that is not rape, that can't happen. And in the rape law, the rape law was also amended in 2013, Criminal Law Amendment Act, which says that the age of consent is 18, which means that if you are having, if anybody has sexual relationships with any girl under 18 or any boy under 18 years of age, that would constitute statutory rape. So what was 16 under 375 now becomes 18. So that problem is gone. Okay, 15, 16, 18, these three ages have now been resolved, and the age of sexual consent is now at 18. So ideally, we should think that the problem is over. It's now clear. All these problems in the law, the discrepancies and the contradictions in the law have been resolved. Yes, legally they have been resolved, but it has thrown up other issues. This is that because POCSO says that having sexual relations with a minor would constitute sexual offense. What happens in a case where a young girl is in a consensual relationship with another young girl, or one of the parties is a minor, the other is a young adult? Maybe the girl is 16, the boy is 19, or the boy is 16, the girl is 19, whatever. Or both are minors. Or it could also, I'm only talking in heterosexual terms. There could also be non-heterosexual relationships here. If either of the parties is 18, but they are in a consensual relationship, the law does not recognize that. So there is no recognition of adolescent sexuality in these laws, including the POCSO and the PCA, the prohibition of child marriage. So as if that people become sexually active on reaching the age of 18. Before that, they are all like asexual beings. And we know that that is not true. So what happens when two minors are in consensual relations, or when a minor and a major is in a consensual relationship? And if there is a complaint from either of the parties, and in most cases in India, it is the girl's family that brings in a case against the boy. Say these two kids have eloped and there is a shift in child marriage. I'll just briefly talk about it. Imagine that these children have run away and they have got married or they have had sexual relationships. In most cases, it is the girl's family that brings in a case of kidnapping and abduction against the boy. And the police apprehends them. What happens? If he's an adult, it is the adult criminal justice system. If the boy is under 18 years of age, then in the child criminal justice system, and he becomes implicated as an offender in the law. So there, and maybe the girl can say that no, this was a consensual relation. I loved, I'm romantically involved. The law will not listen. Though every stakeholder in the law, from the police to the judges to the social workers, maybe they understand that this is consensual. The law does not allow a space to recognize under POCSO romantic relationships of minors. So this complete non-recognition of adolescent sexuality becomes terribly difficult under the law. And in fact, in a POCSO case, any random person can also say that this girl who's run away with that boy is a minor, and so you can start a case on that basis. So that is another conundrum where no recognition of adolescent sexuality, participation, their say in the legal process can work. So this is a problem under POCSO. And the idea that all sexual relationships are within marriage, that is another understanding. You say that the age of marriage is 18, so the age of sexual consent is also 18. As in, all sex happens in marriage and nothing happens outside it. And if it happens outside it, there is a problem. And if a minor engages in that, then that is criminally prohibited. As if everything will now only happen in marriage. So what happens to all of these people? They become criminalized and victimized. The girl becomes a victim, though she had consented. So that is a problem. There are reasons why this was done to prevent trafficking and all of that, but we have to recognize that there is a problem here. Um, uh, um, so, so the non-recognition of adolescent sexuality also has its implication in the Prohibition of Child Marriage Act. The Child Marriage Act actually still has this provision for voidability. It says that a girl, she can be married off, and when she becomes a major, then she can appeal to the court to declare that marriage void. So what does this law mean? Does it mean that this girl who, say, for example, got married at 17 and actually had sexual relationships with her husband, then is the husband now implicated in the law? Does he also become a criminal under the law? That is one problem. We don't know. If there is nothing, there is no sexual relationships under the age of 18, then how does the Prohibition of Child Marriage Act retain the clause of voidability? It cannot retain the clause of voidability. It's not possible. Because the moment you have voidability, you therefore recognize that there is some sexual intercourse happening before the age of 18. And you're saying voidable, leave it to the girl or the boy to determine. So how can that happen? And this, so that issue of, therefore, are we trying to criminalize the husband for doing this, for marrying a minor? In a sense, the idea is that you will not marry a minor. But you will not marry a minor, and therefore no sexual relationships happen. That therein is the problem. One part is you will not marry a minor. So if you marry it, then the potential of the law to criminalize the husband is strong. That is one part. But in the same vein to say, it's not marriage, but all kinds of sexual relationships are therefore prohibited. I mean, till 17 years and 364 days, you will not have any sexual relationships. And then you will have when you're 18, on your 18th year. Is that reality? Is that what we want for our children? This is another space of discussion. And there is this recent discussion which happened during 2021 was to raise the age of marriage from 18 to 21. And it seems that this is great, like girls will also now marry at 21. Why this gender difference that boys marry later and girls marry earlier? Best is to push the marriage of both the girl and the boy so that she can complete college, she gets certain things to do with her own life, etc., etc. So apparently the raising in the age of marriage seems good, seems a positive, progressive thing. But many people think that this is not without its dangers. Is this apparently progressive legislation that is being recommended actually to obliterate or to sort of not to show the real intentions, quote unquote real? And what could they be? That now also women are not, they don't have much of say in their marriage, in expression of marrying a person. Sexual choice and autonomy of women is still so restricted. And does this mean that this is a backdoor again to prevent women from marrying men or having relationships with men of their choice, which is inter-caste, inter-community marriages will now be more prohibited ever than before? And this is a real concern, given that there is so much of resistance to intercaste and inter-community marriages in India. There is a lot of honor killing as well. Is this a backdoor to say that we will restrict women's choices till they're 21? And so a 19-year-old woman cannot choose to have a relationship with somebody of her own choice and always have to be what the family suggests is the best for her. Is that a real danger? Should we focus on 18 as the age of marriage and try and change other things in women's lives, right? Just raising the age of marriage is not going to really help without changing the socio-economic, political circumstances in which girl children find themselves. Unless we change our attitude toward girl children, just raising the age of marriage will not be helpful. Even now, 18 is not possible. Will 21 be possible? Or will this make child marriages more and more common because it's going to go more and more underground? Even with 18, we see families trying and doing something. If there is resistance by the police, they will overnight take the girl to some other village and get her married off. With 21, will this increase more? We don't know. So the latest debate, the latest conundrum that we have to sort of talk about, I think, is the non-recognition of adolescent sexuality under the POCSO. So what happens to Prohibition of Child Marriage Act, voidability clause? What happens to POCSO when children are in consensual relations with each other, or one party is a child, the other is a young adult? And finally, does raising the age of marriage from 18 to 21 be beneficial to women in India? These are the other questions that center around the law in contemporary India today. With that, thank you very much. I'll end the talk here. Thank you.
Ruchira, I have to say this was a very disturbing talk, because all along I've been slightly embarrassed that in my head I cannot disentangle some of these questions. I mean, age of consent, age of marriage, as an older person who's learned many different variations of many different things and never quite kept up, I've always kept quiet in these conversations. And I'm very disturbed to learn that the law is equally confused. I should take some comfort from that. But, for example, if the age of marriage is 21, does that mean that nobody can arrange a marriage? Or the parents can arrange a marriage, but children cannot choose to get married? These questions, and you also teach film. So you know that this confusion is furthered by depictions in cinema of rules and customs interchangeably. So the result is, if people like me, who should know better, have no clue, how do we move forward? But, I don't think that that's, I'm also want to say to everybody, the floor is now open. We're a small group, so please raise your hand and chime in. If you want to respond to that while people are formulating their questions, then I leave my confusion as question number one.
So the question is that, can families get their children married off, but children themselves cannot choose? One is, if you go by the Prohibition of Child Marriage Act and the POCSO combination, you cannot get your girls married off before they are 18, or girls cannot marry themselves before they are 18.
Okay.
That resolution has happened between the PCMA and the POCSO. My problem was that there has been a terrible premium on marriage. Everything around sexuality seems to revolve around marriage.
Yeah,
and the
right.
complete non-recognition that people can choose to be in a relationship and not get married, and children, adolescents in India are sexually active. The law doesn't seem to recognize this at all. But the other problem that I said is that since the Prohibition of Child Marriage Act's voidability clause has not been resolved, it means that, if a girl has gotten married, that marriage stays. And how many kids in India will say that, I got married 2 years back, my family forced my marriage, I want to break out. That is not a possibility that is happening a lot.
Yeah. And as we know, I mean, even the more prominent provisions and prominent laws, there is still a great deal of ignorance about them. So when you take something that is one provision in a law that people still don't talk a whole lot about, then what is the likelihood that the girl or the boy will even know that they can void the marriage?
Exactly. How many people even know that void clause exists is the first question. And assuming that they know, how many would exercise? What are the ways out? I mean, what do you do after that? But I'm not even trying to implementation at this point.
Yes, ma'am. Good morning. That was a very enriching talk. I had a question on how reproductive rights basically plays into this, because if you have a minor who is, married off early and then she has to get an abortion, how does a law recognize that if the law doesn't really, look into adolescents or young adults having any sexual agency?
Absolutely. If you're looking at the abortion laws and the clauses, what we find is when, say, an unwed teenager finds herself pregnant and goes to seek abortion, especially in government clinics, they would ask for her age, and then they would actually call for her parents and say that, at least, since this is an abortion case, you would have to have at least your mother with you, etc. And maybe she does not want anybody to know. And because she cannot access the health system in a legal way, we see these adolescent girls therefore go to unregistered doctors or quacks and getting unsafe abortions. So it impinges largely on lives of young mothers, because it endangers their life. Because the law would expect you to sort of have your parents, and also, interestingly, abortion cases, what would happen? They will now file POCSO, because the doctor, on knowing that, she figures out that this age of this girl is around 16, which means she's had a sexual relationship, which is prohibited by law. Therefore, the doctor will have to inform the police that this is a POCSO case. And the moment it becomes a POCSO case, then that entire system comes into wake. Then what happens to this girl's ability to seek abortion without anybody, for example, knowing about it? It won't happen. And then the parents will come in, etc., etc. And then maybe she can seek abortion. But her autonomous self is completely obliterated. It would automatically become a POCSO case, which means that if she's had a consensual sexual relationship, she's not pregnant as a result of the rape, that man will also be implicated in the law. So that is a real issue here.
Thank you, ma'am.
Unmute.
Sorry. Thank you, Ruchira, for this wonderful talk. Actually, recently I met a couple in a police station. So they are underage, like say the boy is, both of them are 17 years old, about to be 18 years old. So they eloped and got married. But in the police station, the parents were like, want them to go back to them, and it became a POSCO case. And then I was wondering, like, the girl does not want to go back to the mother, and also in-laws are also not taking her in. So she is under, I mean, he was under like arrest and everything. So I was wondering, I was there for some time, but everything was going on, and it was really confusing to see the scene. And Nobody knows what is going to happen, and even the police, well, because they are about to be 18 years old, and it was like kind of bit confusing. So I was wondering what will happen to the girl if the boy goes to the jail, whatever, imprisoned or something.
It's a very common occurrence now in India, and a lot of people are concerned. This is a very typical case. So when the girl refuses to go back to her parents, and she can, because she's not 18, she cannot go to the boy's house.
Yeah.
Even if, first of all, maybe here in this case the in-laws don't even want, but even if they would have wanted, the police would not release them to the husband and his family. He's still a child in the eyes of law, and she will have to be sent back to her parents. Because she refuses, a lot of these adolescent children, say from 14 to like 17, etc., then if she refuses, then she's sent to a children's home. So she goes to a government home, a child care institution. Cases where such young people who have eloped, married or whatever, and they have been immediately apprehended and brought back by the police, then what happens? The girl basically says, I'll go and stay in a sarkari home. I will not go back to my parents, because if, and many of them say, if I go back to my parents, they might get me married off forcefully. So parents, I found this very interesting, that parents would rather prefer to marry their underage daughters to some random fellow, but they would, but will not allow her to exercise her own sexual autonomy. They would rather that their daughter is a rape victim. They would rather say, you know, she was raped, but will not acknowledge her sexual autonomy. So this speaks a lot about patriarchal mindsets that we have today. This boy will, if he's over 18, so then he will be sent to the criminal justice system. Will be there in police custody, will be put in court, depending on what the court finds, will be sent to jail. If he is a minor, imagining that both are 17-year-old, then the police will apprehend and send him to what we call the Juvenile Justice Board. And the Juvenile Justice Board will now evaluate the case and see, and then when he goes up after, and then, you know, it depends whether the Juvenile Justice Board will send him probably to a special home, an observation home and a special home. So both of them basically land up in childcare institutions. The POCSO Act is very strict, and there can be more interpretations. If the girl's family brings in a case of rape against the boy, and if he's 17, which is a heinous, serious, it's a heinous crime under the law, then he will not, it is not restricted that he will only remain in the Juvenile Justice Board and will have to remain for a maximum period of 3 years in a special home for children. But he can also be treated as an adult and sent to an adult criminal justice system. So maybe he will end up in jail for a significant period of life. So their lives become really complicated. And even, I mean, we know certain cases where the JJB let off or the courts let off, care. But look at the trauma that this two young people go through. You know, he will be in police custody for some. He will be in the JJB. You know, stigmatization. Maybe he was in high school. Now he cannot go back to school. We know of kids who have lost. They were supposed to appear for their boards, and they could not appear for their board. All that they did was to run away for one night someplace and got into real trouble. So all of that complexity happens. It's really sad. But there are case laws now which say that, you know, POCSO is typically a case where an adult sexually abuses a minor. Those are those cases, you know, real sexual offense on children. When the law came, we did not imagine that young people will get into trouble for expressing love and sexual consent. So I think that's everybody understands that they cannot get out of it. There are some case laws now that say that you cannot implicate, but there is no amendment in the law. We just have some case laws recently recognizing that we have to make a distinction between real cases of sexual abuse of children and cases where they are in a consensual relationship. Knowing fully well consent is a very broad thing, but consent is problematic both for adults and children. I mean, let's not make it further more difficult.
Actually, the complications you did not mention today were actually this intersection between the juvenile justice system and the adult. I mean, that's another layer of this, and the complete absence of acceptable, reasonable support systems. You know,
Exactly.
so what is the quality of the homes, and what is it that, as you say, what do they have to look forward to once they enter that system?
Absolutely. It's a really bad system.
Yeah, I still remember
I
that
wanted to
girl
ask-
was the girl was going on telling like she wants to live with him. So kind of it is the consensual. It is not like forced or something. So
No,
yeah.
the law will not, the POXO law will not recognize, and the Prohibition of Child Marriage Act could have recognized avoidability, but now that is the problem I was talking about. The avoidability clause exists, but you have POXO. Now, how do you do this? And all these resolutions therefore happen on an informal level and all of that, which is even more complex. What happens if the girl now goes and starts staying in with this boy, and then say 1 year later she runs into trouble? Then would it be voidable? So it's like opening up multiple Pandora's box, not just one. So many layers of these problems.
But they're also only Pandora's boxes if we stick to patriarchal notions around chastity and protection and so on. The moment we can begin, because you look at other societies that have walked these debates, one resolution is that they have begun to let those ideas go.
Absolutely.
But we want the appurtenances of modernity, and we want to hold on to all our patriarchal ways.
Because this conversation has also happened, but I don't think it's made an intervention that so strongly that in many jurisdictions that the age of marriage is 18, but the age of sexual consent may be 18. You can make a distinction between, you can make a distinction between the age of marriage and the age of sexual consent. They mean to be the same, which was in the rape law. The age of sexual consent was set at 16. So if you have sex with a girl under 16 years of age, then that would be statutory rape. We raised it to 18. Why? Because POXO says 18. Why? Because why does POXO say 18? Because age of marriage is also 18. And globally, the age of childhood is 18. I mean, till 18. So this trying to bring in age of marriage and age of sexual consent on the same plane is exactly what you're saying, Swati, which is notions of chastity, everything is within marriage, complete blindfolded to the idea that children are active. What do you do about that? What happens? All of that is there. So I think that the solution lies, if you're looking at the Prohibition of Child Marriage Act, the solution lies in prevention, that people will, typically what we think of the law, that the law would act as a deterrence. And we know that the law has never acted as a deterrence. So the idea—
If you don't know they are there, how will they deter you?
Exactly. And even if you did, I mean, when we went to communities to speak about child marriage, a lot of people actually know that these laws exist. But then cultural practice, thinking of the girl child as a burden. And now I think a lot of families think the girl child as a burden because, they're all aware of the fact that children become sexually active and they're very scared that, what happens if she does something before that, get her married. Then all problem. So So I think those are all these issues.
But also, Ruchira, I mean, it's the question of the anxiety about sexual activity. But if you look at, in a larger sense, all of our societal governance failures, it is also when you're displaced, you know, what happens if you get separated from your girl child and she doesn't have a family of her own? What happens when both parents die of COVID and the child is left on her own? So this, in situations, in emergencies like this, we know that, you know, marriage is just a way, literally a way of securing your child. And we may not think it always means security, but sometimes for parents, it's the only security they can think about.
Yes, yes, absolutely.
And if we don't sort those problems out, it's also about, you know, dismantling the enabling conditions for these things.
Absolutely, absolutely.
Are there other questions for Ruchira? If not, we will thank you, Ruchira, and let you move to your next thing, which I know you delayed on our account. Thank you so much for coming. Come back. And we really, really appreciate this. This was an illuminating talk, and I don't use the word lightly at all.
Thank you so much. I mean, it's been a pleasure. Thank you very, very